movie in the morning the day after. And by the afternoon, she was fine, and we had nothing, no pain, no anything.
No, that's
I'm opening up to everyone.
okay.
Nobody that I know has had any side effect.
No, I've not heard of anyone. Yeah. Well, that's good. So let's hope it all rolls out and covers everybody and we don't. Oh, and my power's just come back.
Okay, must I continue?
Well, yeah, I'm waiting. Everyone's going to be starting to join now. I see everyone's everyone's flooding in now.
Good.
So that's my, I don't know if you can see it.
No, it blocks it out. Whatever you're trying to show us, it censors it.
My COVID-19 vaccination card.
Oh, God. I thought you were going to show us where you had it in your arm.
No, you can't even see that. Nothing to show. But everybody wears it as a badge of honor. Have you had your vaccine? Yeah, I've had mine.
Well, it's good, hey? I mean, at one stage there was seemed to be a whole lot of anti-vaccine people that were kicking up quite a stink. I'm glad that now people are just saying, let's just get on with it and just do this thing.
You know,
the anti-vaccine people are still around, but they've been quiet and by everything.
No, I've got a few friends who said they weren't going to have it, and then all of a sudden they were having it because they realized they didn't have it, they wouldn't be able to go overseas. So all of a sudden,
I think that's the big thing. Wait till time comes to travel, and then suddenly you can't go and see your kids in the States or whatever. I mean, it's just, it's not worth taking that risk.
Yeah, it's a controversial one, but I don't see the problem in vaccinations, but
frankly, I don't care if it's 10% or 20% or 100% effective. I'm having it one way or another.
Yeah, no, sure. I mean, it's like you say, we have the flu shot every year. You know, I mean, when my kids were small, they all had the measles and mumps and all those vaccines. And, I mean, you just do it because the alternative is just too awful to think about.
Why would you want to risk that?
No, it's just not worth it. For the sake of just having the vaccine, even if you had to pay 400 Rand for it, I mean, it's just better to have it.
One day they're going to put a little chip in your body, and when you want to have these, you'll just send a message and zap, you'll have the vaccination. You'll have the...
No. Hopefully we don't get to that. But I don't think this is that. I mean, this is just a vaccine. Yeah.
Listen, it's not beyond the realm of possibility.
Yeah.
Well, some people are testing it already, but it's not that bad.
That would be a bit problematic, but but I don't think that we should confuse the vaccine with that. Yeah. But who knows? Maybe this is just softening us so that we just get used to just having whatever's going. Who knows?
Yeah. Just wonder how many people are still alive in China. They don't tell you anything.
Yeah,
I think we're up to about 60% of people joined. So I don't know if we should start and we'll carry on. Those who join late can catch up.
Sure.
Okay, so welcome to the 2021 mid-year update with the latest developments in case law presented by the one and only Professor Jackie Arendse, and who needs no introduction. I hope those of you who've had their COVID are sorry about that.
Switch mine off.
COVID, that was the COVID line. The COVID people have had their vaccines, and who are over 60 and those others who are waiting patiently, you get it in good time. And so, Prof. Jackie, the floor is yours.
Great. Thank you very much. Thank you, Stan and Danny. And welcome, everybody. It's lovely to have you here. I can't see you, but hopefully you can see me. And hopefully you can hear me. That's the main thing. And yeah, it is my pleasure to be running through this webinar with you this afternoon. Mid-year update. Don't panic. We're not quite in the middle of the year yet, although it's not too far away. But yeah, there is quite a lot to cover. And so I think it's always a good thing to kind of pause in May, get up to speed with what's going on. Because, of course, by November, we have the next lot of legislation amendments, and then it's, onto all of that. So at the moment, what we're going to be covering is quite a lot of case law that has come through over the last few months, basically starting from December last year. Then I'll have a look at some SARS documents. And then I'll address some of the queries raised by some of the attendees that Danny had asked you if there's anything specific, and the questions that did come through in time for me to incorporate into this presentation. I've done that. There were one or two that came through a little bit late to put into the presentation. I've answered those offline. So if you do have any questions that you want to raise relating to any of this stuff, you're welcome to raise those questions as we go along. So you can use the chat box there or the Q&A. I'll just have a look from time to time, probably not all the time during the presentation, but certainly at the tea break. I'll have a look and see what questions are there, and then we can have a look at answering them. Okay, so speaking about the tea break, so I think what we should do is at about 25 past 3, we'll take a tea break for about 15 minutes. We're due to finish at 5, but yeah, hopefully I won't keep you through right through until 5. We'll finish a little bit before, but not too much before. So we'll finish between, say, 4:45 and 5 o'clock. For those of you who are planning anything else, then at least you can plan your life accordingly. Okay, anyway, let's go straight into the case law judgments. And as I say, there are a few judgments that have come through. In fact, one of them just recently this week, the Clicks Retailers Constitutional Court case. Just to sort of keep us on the edge of our seats, because there's always something new in the tax world. So we've got 2 constitutional court cases, 2 SCA cases, and a few high court cases. All right, so let's just go straight into them. So the first case, this was a constitutional court judgment handed down in December 2020, so within the last 6 months. And it's a case involving the public protector and the commissioner of SARS. And it links to the secrecy provisions in the Tax Administration Act. And of course, the public protector, we all know some of the media stories going around linked to this, but what had happened is that the public protector was investigating a matter that had been reported, and it was based on issues around our former president, Jacob Zuma, who was supposedly on the payroll of a company but had not declared income, etc. And Mr. Mmusi Maimane, who was then leader of the opposition, of course, he subsequently stepped down, but at that stage he was, and he laid a complaint with the public protector. So she was then undertaking investigations following on from this complaint. In the course of carrying on her investigations, she issued a subpoena for the commissioner to appear before her and produce documentary information and evidence. Now, the commissioner argued that he was barred from doing so and could not divulge any information on a taxpayer. So the public protector was saying that, okay, you might have the secrecy provisions there in Section 69 of the Tax Administration Act, but this is the public protector. And so the argument was that in this particular circumstance, the secrecy provision didn't apply, and that the taxpayer's information should be put forward for her to conduct her investigation. Anyway, the judgment was handed down, went through to the Constitutional Court. First of all, had been through the High Court, and also there was an issue of costs. The High Court had issued a cost order against the public protector in her own personal capacity, saying that she had to pick up 15% of the costs of the commissioner. And she took that on appeal to the Constitutional Court to say, as to whether that particular order could stand. So the matter went to the Constitutional Court, basically the commissioner opposing the application to appear before the public protector with the taxpayer's information, and the public protector appealing against the High Court order, instructing her to bear the costs in her own personal capacity. So I'm not going to spend too much time talking about the case, but just suffice to say that the court ruled that the secrecy provisions are sacrosanct and that the public protector cannot pierce that veil, as it were. And so the taxpayer's information could not be divulged to the public protector, and he could not be compelled to appear before the public protector and present the taxpayer's information. On the matter of the order around the costs, so the High Court had ordered, as I say, that the public protector must pay 15% of the costs of the commissioner out of her own pocket. And the High Court had argued that that was because the public protector had basically not acted properly and possibly had even acted in a kind of a fraudulent way. Nonetheless, the Constitutional Court spent quite some time looking at this question about the private cost order. It's got nothing to do with tax as such, but it's just interesting in terms of cost orders, but came to the conclusion that, if this went ahead, it could create quite a bad precedent, a dangerous precedent. And so basically what the judgment said is that the court cautioned against the growing trend of seeking personal cost orders, especially in cases against the public protector. And it urged courts not to fall into the trap of thinking that the public protector is fair game for automatic personal cost awards. So the Constitutional Court emphasized that the fact that 4 out of the 4 matters that had come before it, and in which the personal cost order against the public protector were at issue, it sanctioned a personal cost order only once. So basically the Constitutional Court ruled against the personal cost order. All right, but certainly re-emphasized the issue around taxpayer secrecy. So I think that's really important, especially if you're going to have a tax system that people can rely on. The secrecy of the taxpayer, confidentiality of the taxpayer's information is absolutely critical. Okay, so interesting outcome there. And then in this recent case of Clicks retailers, those of you who've been following developments in tax over the last couple of years would remember the SCA case involving Clicks retailers. That was actually a judgment that was handed down in December 2019. And what had happened there is that the Clicks retailers was claiming the Section 24C allowance for future expenditure. And basically SARS had disallowed the deduction. The taxpayer had taken the matter on appeal. It had gone through to the SCA. Taxpayer lost the case at the SCA. And here we see that they took the matter through to the Constitutional Court. Now, it's quite interesting because in July last year, there was another Constitutional Court case also dealing with Section 24C, and that was the case involving Big G Pty Limited. And Big G was a company that ran Spur and Panarotti's restaurants and under the Spur and Panarotti's franchises. And they had also claimed the Section 24C allowance. They had also lost their appeal, lost at the SCA, taken the matter to the Constitutional Court, and the Constitutional Court ruled against the taxpayer and did not allow the Section 24C allowance to be claimed. Now, what was interesting is that in that judgment of Big G that was handed down in July last year, the argument came around this question of same contract, okay? So Section 24C applies, the deduction is allowed when a taxpayer receives an amount of income and they have an obligation to incur expenditure in the future under the same contract. Now, of course, the issue is whether in these circumstances, the Spur situation and the Click situation, whether it could be said that these were the same contract. So when Clicks went through to the SCA in December 2019, as I say, they lost well, SARS took it actually on appeal in 2019. The taxpayer lost that case, and SARS was successful in saying the 24C allowance did not apply because the contract for the earning of the income and the obligation to incur expenditure was not under the same contract. Now, this linked to Section 24C, and as Section 24C read in 2009, you don't have to go through everything on the slide, but basically it speaks about the income received and expenditure incurred under such contract, all right, under the same contract. Then there could be an allowance for the future expenditure. If you think back to when Section 24C was actually introduced into the Income Tax Act, it was specifically focused on a sort of a construction type contract where, let's say you entered into a contract, if you were a construction company, you entered into a contract with a client and you said, right, pay me 100,000 Rand and I will put up a garage for you, whatever the case might be. So the 100,000 Rand comes in, and let's say on the last day of the year of assessment, the construction company receives that 100,000 Rand. They're taxed. It comes into their gross income. Any amount received by or accrued to the taxpayer during the year of assessment, that comes in. But then the deductions for the expenditure incurred, that only happens in the following year of assessment. And so you have this timing issue that you have the income taxed up front, and then you only get the deduction for expenditure incurred in the following year of assessment. So Section 24C allowed an allowance for that future expenditure. So let's say if you got the 100,000 Rand income on the last day of the year of assessment, and you knew that you were going to have to incur expenses related to that contract that's going to amount to, let's say, 80% of that income, then your Section 24C allowance would be 80% of the income you get as the allowance. So you're actually only taxed on the kind of gross profit, if I can put it that way, of 20,000 in year one. You get the deduction of 80,000. Next year, you add back that deduction, so that comes into income. Of course, if you actually incur the expenses, you claim that as 11A or allowance expenses, deductions. And then if there's still future expenditure at the end of the following year, another deduction is worked out at the end of the following year. So that's what 24C was designed for. So your income received and you've got expenditure incurred under the same contract. Now, in the case of Clicks retailers, Clicks was operating a loyalty program. And so they were arguing that every time they had a sale, portion of that sale, and it amounted to pretty much 2% of their income, if the customers had a club card, then basically the benefits under that club card, the loyalty benefits, amounted to 2% of the value of those sales. So let's say they get 100 Rand in on when you go and buy yourself a deodorant or a tube of toothpaste or all of the stuff like that. All right, so they're saying out of that, 2% of that is going to have to be expended later on when that customer comes back and presents their club card when they make a subsequent purchase, and they're then going to cash in their loyalty points to get a discount or cash back or whatever the case might be. Okay, so it's that subsequent expenditure. And so they were arguing that this happens under the same contract. It's under the contract of sale that you have the obligation for future expenditure. Now, in the SCA case, the judgment held that it's not the same contract. The judgment said that there's actually various contracts in operation here. It said that you've got the contract of sale. There's also a separate contract when the customer goes and signs up for a club card. And then there's another contract when there's a subsequent sale, and then another contract when that customer presents that club card and claims their loyalty points. And so they said it's not under the same contract. Now, what is interesting is in the Big G case, which I said went to the Constitutional Court in July last year, in that case, they looked at this concept of inextricably linked. Are the contracts inextricably linked? But they said that in itself is not enough. They said there must be an element of sameness. And so the Constitutional Court judgment in BG ended off by making an interesting statement that they said that the contract of income and expenditure, right, doesn't necessarily have to be on exactly like the same piece of paper, but they said in the judgment, there must be an element of sameness, that it must, even if it's two contracts, they must be so close that they basically one can't operate without the other. Now, it was left there, and there was some uncertainty as to exactly what it was meant when it was referred to as the sameness of the contracts, that it doesn't have to be on the same piece of paper, literally, but there must be an element of sameness. It must be more than just being inextricably linked. And I would suggest that this is possibly why the legal counsel in CLICS proceeded through to the Constitutional Court to try and get clarity on this matter of what do we mean by having the sameness in the contract. I mean, can we literally have two different contracts that are just really very inextricably linked, or is there more required than that? Now, picking up in the judgment of CLICS, now going to the Constitutional Court judgment. In paragraph 14, this is from the judgment of the Constitutional Court, it says that in Big G restaurants, the SCA confirmed that Section 24C does not envision different income earning and obligation imposing contracts. The court expressly rejected the notion that Section 24C applies where there are two or more contracts that are inextricably linked, okay? Saying that, that's not sufficient. You can't just have contracts that are inextricably linked. There has to be the same contract. And then it goes on in paragraph 21 to say that in Big G restaurants, this court accepted, and that was now in the Constitutional Court case, right, of December 2020. The Constitutional Court accepted that it is a requirement of 24C that the contract in terms of which the income is received must be the same contract under which the obligation to finance future expenditure arises. However, it also held that two or more contracts may be so inextricably linked that they may satisfy this requirement of sameness. All right, so it's inextricably linked, but so closely linked that it's pretty much regarded as the same contract. So what do we mean by this element of sameness? On the facts of that case, there was a lack of correlation between the income producing sale of food, remember that was the Spur restaurants, Panarottis, and the obligation imposing franchise agreement. So they said there was not that element of sameness. But now along comes CLICS, and CLICS is basically arguing that they do have this element of sameness. And so the judgment goes into quite a lot of detail in terms of saying, how much is required if you don't exactly have the same contract, one and the same contract, how closely linked must these contracts be to be regarded as having this element of sameness, all right? So because in Big G, the court accepted that there must be this sameness. So what do we mean by that? So in paragraph 22, it goes on to say the crisp issue for determination is whether CLICS can claim an allowance under 24C in respect of the income it earns under its loyalty program. And this is saying we've got the future expenditure. Can we get the 24C allowance for this future expenditure? Following the Big G decision, the 24C allowance can be claimed either when the traditional same contract, so one and the same contract on the same piece of paper is met, or when the income and the obligation arise from two contracts that are so inextricably linked that they meet the sameness required in Section 24C. And so then they had to go on to decide whether in CLICS retailers, they actually met this requirement. And I'm jumping all the way forward to paragraph 49 of the judgment, where they basically say, and actually it's interesting because there's no evidence that CLICS really demonstrated this element of sameness. They just kept going on about the fact that, the loyalty program flows from the sales that they are making. And so finally, after looking at this whole question of inextricably linked, but to the extent that there's this element of sameness, at the end of the day, the judgment came to the conclusion that the contracts, now you got the sale contract and the loyalty program contract, they said those contracts found CLICS claim for the 24C allowance gave effect. The functional relationship manifests in a number of factual and legal links between the two contracts, but the links do not render either contract dependent on the other for its existence, nor is the effect that income can only accrue to CLICS if both contracts are in place. So this gives us an understanding of perhaps the interpretation of this element of sameness. Sameness would be where the one contract cannot operate without the other. The two are completely interconnected. Whereas in the case of CLICS, CLICS could have a sale and it wasn't reliant on the CLICS card. On the other hand, you could have the Clicks card presented and claimed, loyalty points elsewhere, not necessarily linked to Clicks sales and income. And so the contract under which the income accrues and the contract under which the future expenditure arises are two independent of each other to meet the requirement of contractual sameness. Although they may operate together within the context of the loyalty program, and in that sense they are inextricably linked or connected, but that link in itself is not sufficient. It would have to be that the contracts stand and fall together. Then they would be regarded as having this element of sameness. Okay, so at the end of the day, after all of that, Clicks lost the case, and the order was that the appeal was dismissed, Clicks' appeal was dismissed, and the applicant had to pay the respondent's costs, including the costs of 2 counsel. So that would have been rather expensive time in court for Clicks. But yeah, I could only think that, we might say, well, why did they go to the Constitutional Court after Big G had already done that and lost? But I think it was to pursue this aspect of sameness and trying to get interpretation around what do we mean? How closely linked must these contracts be in order to meet this requirement of sameness? All right. And it came out that they must be so inextricably linked that the one cannot really stand without the other. Then you would regard them as having the element of sameness, that it would be regarded as under that contract that the expenditure must be incurred, and then you'd be able to get the 24C allowance. So interesting developments around the Section 24C allowance. Okay, then on to the next case, which is actually a VAT case, the Consul Glass case. And this one deals with the deduction of input tax. Of course, always a perennial question whether a vendor is entitled to the deduction of input tax, and an extremely risky area in VAT because, of course, input tax is allowed in very specific circumstances. Input tax is allowed specifically when it is VAT that is paid on an expense that is incurred in order to make taxable supplies. So it's incurred by a vendor in the course of carrying on an enterprise in order to make taxable supplies. And so, of course, yes, we do also have certain input taxes that are prohibited, like input tax paid on motor car, entertainment, etc. But apart from that, the real fundamental question is, what was the purpose of the expenditure? Was it incurred in order to make taxable supplies? If yes, then the VAT paid on that expense would potentially qualify for an input tax credit. Now, in the case of Consul, they also had another element to this. They had used international consultants, and so they had imported services. Now, in terms of Section 71C of the VAT Act, output tax, VAT, must be raised on imported services, but only to the extent to which those services are used other than for making taxable supplies. All right, so there's 2 elements here for Consul. There's the input tax on local services, whether those local services were used to make taxable supplies, and then there's the output tax on the imported services, which must be raised if those services were not used, or to the extent to which the services were not used for making taxable supplies. Okay, so the key thing here is whether these services were used to make taxable supplies. So what actually happened? So Consul Glass had raised debt funding to facilitate the acquisition of another company. There was a leveraged buyout, but they had raised initially euro-denominated debt back in 2007. Of course, with the deterioration of the rand, etc., that debt would have become very expensive. And so in 2012, Consul sought to replace that with local debt to cut down the cost of the debt. So if you think about that, they raised debt to buy another company, all right, or to buy the shares to arrange the leverage buyout. And then they were looking at replacing the one set of debt with another debt. So that is really, they used the consulting services in that process. So they were using a consortium of local banks to raise funding of about 5 billion rand. And so they paid service and consulting fees to various local banks and attorneys, but then they also used foreign service providers to assist with these transactions, and they were billed admin fees and professional services by these foreign service providers. Okay, so the key thing then is the inquiry is, what were these services used for? because that will tell us whether Consul was entitled to deduct the input tax on the local services and whether it had to raise output tax on the imported services. So what was the purpose of the services? And did Consul acquire these services in the course of making taxable supplies? So we look at the relationship between the purpose for which the services were acquired and the use to which the services were put. And the court made this point in the judgment as to whether there's a functional link. Okay, so here's a good term that we can use. Is there a functional link between the services that were provided and making taxable supplies? Now, if we go back to Consul's actual statement of the grounds of appeal, they said this. They said they operate in a very competitive market. By switching the euro bonds to local debt, they were cutting down their expenses, and the reduction of input costs was essential in order to maintain a competitive position in the market. The expenses that were incurred substituting the euro bonds with local funding was in order to put in place less expensive funding, which would then cut their overall costs, make them more competitive, more productive, and that way they would be increasing their taxable supplies. And so they argued that even looking at the original debt of the euro bonds, they utilized that to acquire assets in order to make taxable supplies. And the substitution of that debt with local debt basically fulfilled the same function. So they were saying this is a debt that has been raised to provide assets for the business. And then when we replace the debt, it's looking at cutting the costs of the business. And this is all important in terms of making us more competitive, etc. The court just looked really very simplistically in a way, and in terms of saying, well, let's have a look at the output of this company. Did it change as a result of these particular service costs that were incurred? So basically, they came to the conclusion that there was no demonstration that, as a result of these consulting fees being incurred, there was an increase in the taxable supplies. Now, they said here, no injustice is done to Consul to hold it to the case that it sought to make out. So it's fine. You talk about being profitable and cutting costs and making yourselves more competitive. No problem there. But the paucity of evidence that bears upon a case predicated upon competitive positioning and the many questions that arise from it cannot be answered on the evidence before us, providing a strong indication that we should not entertain such a case. So at the end of the day, it comes back to the onus on the taxpayer. The Consul did not discharge the onus upon it to demonstrate this, as we spoke about earlier, the functional link between the services that were acquired, the consulting services, and the making of taxable supplies. There wasn't a close enough link that was demonstrated by the vendor. And as a result, the appeal was dismissed. And counsel agreed the costs of the appeal should follow the result. And so the taxpayer again had to pick up the costs of to counsel for SARS. So I think, again, it creates a really important point and re-emphasizes the point that we've seen time and again, that when you're looking at claiming the deduction of input costs, you need to ensure that the underlying expenses on which the VAT input was charged were incurred for the making of taxable supplies. And as the vendor, one must be ready to discharge the onus of demonstrating that there is this functional link between the services rendered and the taxable supplies. Now, in terms of the imported services acquired by Consul, so remember that on imported services, you have to raise output tax to the extent to which the imported services were acquired other than for making taxable supplies. So if these services were not linked to making taxable supplies, then it would be those services were acquired other than for making taxable supplies, and the output tax would have to be raised on those imported services. So yeah, quite expensive, an expensive outcome for the taxpayer there, but really very important. First of all, thinking about imported services, because we see much more prevalent imported services with our much more globalized business environment. And just, I think people often tend to forget that there is this requirement to raise output tax on import services to the extent to which they are utilized other than for making taxable supplies. All right, but then also this question of input tax and when one is able to claim input tax, and that you must be ready to demonstrate this functional link between the expenses incurred, and the making of taxable supplies. Okay, then the next case is Massmart. Very interesting case involving a trust. And this particular case involves a trust that made losses. But what is interesting is that as much as we could say the trust made losses on the purchase and sale of shares, what is interesting is that Massmart sought to utilize those losses in its own determination of their tax liability. In other words, it wanted to set off these losses against its own capital gains. Now, of course, if you think about a trust is a person as defined in Section 1. A trust owns assets. A trust disposes of assets. And when a trust disposes of assets, giving rise to a capital gain, that gain in the first instance will be taxed in the trust, unless paragraph 80 intervened that caused the capital gain to be taxed in the hands of the beneficiary if the beneficiary has acquired a vested right, or indeed, if there is an attribution rule that applies, if the capital gain has arisen as a result of a donation, settlement, or other similar disposition by a resident, etc., or by a parent to a minor child, or one of those provisions of the attribution rules. So it's linked to a donation, then the capital gain could be kicked back to the donor. But apart from that, so you've got your very specific attribution rules, paragraph 68 to 72 of the 8th schedule, and then you've got paragraph 81 and 82 that would take the capital gain to the and to be taxed in the beneficiary if the beneficiary has acquired a vested right to the asset or to the gain in that same year of assessment. Okay, but if you think about all that I've said there with the attribution rules and with paragraph 80A, it talks about a capital gain. It's very specifically, if I just read to you paragraph 80, it says, subject to paragraph 68, 69, and 71, where a trust vests an asset, or it goes on in subsection 2 to say where a trust vests a capital gain. It doesn't say capital gain or loss, it just says a capital gain. So it only contemplates the attribution or the taxation of a capital gain in the beneficiary. You can't distribute a capital loss, because a capital loss is a loss. You can't distribute something that you don't have. Now, in this particular case, Massmart had been advised back in the early stages of the proceedings of the facts that they could not distribute a capital loss from a trust to a beneficiary. What had happened is that Massmart had established this trust in 2000. Now, if you think about it, capital gains tax only came into existence in 2001, right? So when this trust deed was first set up, we didn't contemplate things around capital gains. In 2003, the trust deed was amended, and it provided as follows. First of all, with regards to income arising from dividends, the trust irrevocably renounces its right to receive the dividends, all right? But then insofar as your profits are concerned, profits less losses on the resale of shares acquired to it from beneficiaries or otherwise, it shall not earn any profits because the company is the vested beneficiary. So it states there that the company is the vested beneficiary as far as your capital gains are concerned and your profits arising on the sale of shares. The thing is, this trust was not making profits, it was making losses, because what happened is that the way that the share scheme worked is that there would be a right to acquire shares, let's say issued on the 1st of January, the year 2005, let's say, for argument's sake, okay? Awarding a share participant a right to acquire shares at the strike price of, let's say, R1 per share. The participant could only exercise that right, let's say, 2 years down the line. At that stage, the share price had increased and it was now trading at R1.80 per share. The trust, when the participant then went to the trustees and said they want to exercise their rights under the trust deed, the trustees would then go into the market and acquire the shares. They'd have to then pay R1.80 per share. But then they would award the shares to the beneficiary at the strike price of R1. So they're getting R1, but they're paying R1.80. So you've got a loss. And for as long as this carries on year after year after year and a share price that's going up, this trust is only going to have compounded losses. And in fact, that's what we see happening here, is that the trust suffered losses between 2007 and 2013 to the tune of 954 million rand. Okay, now, rather a lot of money. And Massmart claimed those losses, initially on the basis that it was the vested beneficiary, even though it had been given a legal opinion to say that you cannot distribute losses from a trust to a beneficiary. But they still initially sought to claim those losses on that basis. But they later changed their argument to this argument over here, which is described in the judgment. In a nutshell, they said the argument is as follows. When Massmart issued instructions to the trustees of the trust to offer options to specific employees at specific prices, the strike price, Massmart acquired a right to claim performance against the trustees. And they said that right to claim performance is an asset. And they said that right to claim performance required the trustees to offer the share options, okay? And that right, as I say, they said was an asset. And then once the performance had been carried out, then the asset was discharged. And so they said there's a value on that asset, and then the asset is discharged, so you have no value at the point at which it's discharged. So if you had to put it in simple terms, proceeds, zero, the value of the actual right, the base cost, 954 million in essence. And so you have this loss of a cumulative loss of 954 million. They said, therefore, that it is Massmart's loss. Okay, so quite an interesting argument. So in essence, they said that Massmart acquired a right against the trust to require the trust to grant options to the share participants or the offerees. And then when that trust was discharged, the asset was extinguished, it resulted in a loss for Massmart. Now, if you think this is quite a convoluted argument, I think a lot of people who were involved with this case didn't really fully understand this argument, because there were three witnesses that were called for Massmart. And actually, when you read the judgment, it's quite entertaining in a way, because you have the cross-examination of these witnesses taking place. And what happens during the course of that cross-examination is that the witnesses are trying to answer the questions, but actually what they're doing in the process is that they're actually adding more fuel to SAR's argument as opposed to Massmart's argument. The court was basically considering whether, if you look at the definition of an asset, was there an asset and was there a capital loss? Now, going back, of course, this is in the SCA, and it was an appeal that was coming straight from the tax court, all right? In the tax court, IT 13798, it came back to this question of this right that the company had against the trustees. Is that an asset? And then is there a disposal of that asset that gives rise to a capital loss? So we're saying, does Massmart have an asset in the form of this right against the trustees? And then does Massmart have a disposal of that asset for zero proceeds, but there's an underlying base cost, and that results in a capital loss for Massmart? So that really looks at this definition of asset. Now, if you look at the definition of asset in paragraph 1 of the 8th schedule, it says that asset includes property of whatever nature, movable or immovable, etc., excluding currency, including gold and platinum coins, and any right or interest of whatever nature to or in such property. A right to property. So does this right against the trustees constitute an asset? Is that a right to property in terms of this definition of an asset? They went into some consideration of that, but at the end of the day, they said, actually, really, even if you accepted that the right is an asset, the other question is, has there been a disposal? And that would be the difficulty for Massmart, because you can't show me when did this disposal happen. In fact, they said, if you look at Massmart's assets, the assets there are the loans to the trust. Massmart, in funding this trust, had done so through by loans to the trust. And so Massmart was showing these loans as assets. And so the court was saying they can't see any disposal here. And so they dismissed Massmart's appeal, holding that Massmart purported to account for the trust losses in its books, that it was kind of cooking up this strange argument, arguing that they had actually an asset and they had a disposal resulting in a capital loss. But the court said they could not find any such arrangement, and there was no capital loss for Massmart. So Massmart lost the ability to set that 954 million rand capital loss off against its other capital gains. The capital loss, the court held, belonged in the trust, stayed in the trust, and could only be utilized in the trust. Of course, it is a capital loss in the trust, and so it could be set off against future capital gains of that trust. But in the scenario that I've shown you where the share price goes up, it's very unlikely that there would be any capital gains in that trust. So the capital loss would simply have no benefit. Okay, right. I'm not seeing any questions coming through yet, so I'm going to just carry marching along. So the next case we're going to deal with is MTN, back to a VAT case. And this was a judgment handed down in January of 2021. Right, and this dealt with a supply under the VAT Act and looking specifically at the issue of airtime vouchers. And let me just get this in my VAT Act so that I'm all ready to refer to the necessary provisions. So when we look at Section 10 of the VAT Act, we are basically looking at the value of a supply under the VAT Act. Okay, and Section 10 has various valuation rules. Now, if you look at the starting point of the value of a supply, it tells us in Section 10.2 that the value on a supply, unless provided otherwise, is the amount of the consideration, less the amount that represents VAT, except then that it has specific rules that go through in terms of certain types of supplies. And in particular with vouchers, we are looking at Section 10.18 and 10.19. And the key thing is basically when that supply happens, it links to when the supply actually happens. Now, MTN had asked for a declaratory order requesting the High Court to determine the correct application of Section 10 on a supply of multi-purpose airtime vouchers. So these were airtime vouchers that had been issued by MTN. MTN was of the view that 10.18 applied, and SARS argued that 10.19 applied. Okay, so the key thing is, what do each of these provisions actually say? So there's Section 10.2 that I quoted just now, the general valuation rule. Section 10.18. Section 10.18 talks about a right to receive goods or services to the extent of a monetary value stated on a token. All right, so this would be, for example, if you have a gift voucher, if you go to Sandton City and buy a gift voucher to give to somebody for a birthday present, you buy a voucher with a value. You then give that to that person. They can then take that voucher and go and use it to buy within the Sandton City precinct, and they can then spend that voucher on anything. The key thing is that you don't know what the person's going to spend that voucher on. They've just got a monetary value. Until the person actually buys the goods or services, you don't know what they're going to actually spend the money on. And so you don't know what the supply is going to be. Is it going to be an exempt supply, zero rated, fully taxed, etc.? And so the point of the matter is that here, there's any token, basically other than referred to in 10.19, is granted for a consideration of money. The supply of the token is disregarded. Okay, so when that token is actually issued, that's not a taxable supply at that point. It's only when the person goes to the shop and let's say they take that Sandton City gift voucher and they go and spend it at Zara and they go and buy clothes. Right, now you know you've got a fully taxable supply. Zara then has the supply. They raise the output tax. So you can see how that works. All right. Contrast that with Section 10.19, which actually is much more specific. It talks about a token, voucher, or stamp, other than under the postal services, issued for a consideration, and the holder is entitled on the surrender to receive goods or services specified on the token. So this is much more specific. So the key thing is that if it's a specific token or voucher that is going to provide goods or services as specified on the token or voucher, or by usage arrangement entitles the holder for specified goods without any further charge, the value of the supply of the goods made upon the surrender of the token is regarded as nil. So in other words, there, the supply takes place when the voucher is issued and carries VAT at that time. So it'll carry VAT at the full value, whereas when the voucher is exchanged for the goods, there's no supply that takes place at that stage. All right. So that's why I say it almost comes down to an issue of when the supply happens. So if it's a specific voucher, like SARS was arguing that these airtime vouchers were specific vouchers, they specified the goods or services on the token. Therefore, at the time that MTN issued those vouchers, they should raise VAT at the standard rate. If, however, MTN was successful in their argument and they said this is a sort of a generic type of gift voucher, then there would be no supply at the time the voucher was issued. The supply would happen when the voucher was exchanged for services, okay, and then the VAT would be raised. So that is the issue that came into play here as to which of these two provisions actually applied. All right, so as I say, MTN was arguing that it was Section 1018 that applied. It was a kind of a generic voucher, and therefore, there would be no VAT at the time the voucher was issued, whereas SARS argued that it was a specific voucher, specified the goods and services, and therefore there should be VAT at the time the voucher is issued, and it will be VAT on the full amount. At the end of the day, the outcome of the case was the interpretation ascribed by the respondent is correct. In other words, SARS, that it is a specific voucher, not a general kind of gift voucher. And therefore, the application of MTN was dismissed with costs. Again, costs including the employment of two counsel. Now, it's quite an interesting point here because it also links into the digital era that we are moving into. So if we had to look at kind of old-fashioned thinking, literally having a gift voucher versus airtime voucher, one might be able to draw this clear distinction. But there has been the argument made that the modern world that we're moving in, you might get airtime vouchers, but you can actually use those for a multitude of different things. And so there is some criticism around this judgment as to whether this is actually the appropriate outcome. Of course, all that has to happen is that MTN must just change the terms and conditions of their vouchers to make them non-specific. And then they would be treated more in the nature of a gift voucher, and then you'd be more into the nature of 1018. And it would seem that that would be the route that they would go, because it does seem that these air vouchers are not as specific as literally exchanging only for airtime, that you can exchange them for many different things. Okay. Right. Let's go on.
There's a couple of questions but going to the previous one about the trust. I don't know if you want to look at that.
Have a look at those. Yeah, let's have a look at those. Okay, so let's have a look at Mervin's question. When a trust acquires shares in a company at proper value, when can the company declare dividends to the trust? Well, the trust has acquired shares in the company. The trust becomes a shareholder, right? So the company can declare dividends go to the shareholder, which in that case would be the trust. I see it carries on here. The shares were allotted by the company to the trust. So if the trust is a shareholder in the company and the company declares a dividend, that dividend would go to the trust, unless it was a fully vested trust where the dividends flow straight through and go to the beneficiaries. So it just depends on what kind of trust we are talking about and the specification in the trust deed. So Colin says, is the voucher a future contract or a financial note? It's actually, I would suggest, if I had to choose between those two, I would suggest it's more in the nature of a future contract. So yeah, but I stand to be corrected there. But all we're looking at in terms of the VAT legislation is the VAT treatment of these different types of vouchers. Okay, so I hope that does.
And then another thing, it was probably going to make it very confusing is now, like, Vodacom's now doing it, is now you can use your airtime to purchase at other stores. You don't have to actually purchase through Vodacom. Like where you can buy Nando's now with your Vodacom. So
yeah, so that's it. Yeah, so see, this is the interesting point that comes out of this judgment, and some of the criticism of the judgment is that, yeah, it's not as specific as saying that you can only exchange the voucher for airtime, and that's exactly the thing now. You see, is that that you can exchange that voucher for other things. Just trying to get rid of these questions now.
They're gone. On my side, they're gone.
Oh, are they? Okay. I'll get rid of them when we take a break just now. But yeah, so that is exactly the issue, of course, is that you can use these airtime vouchers for a multiple of different things. And so was the outcome of this case, let me just go back one slide here to just refer back to this case. Was the outcome of this MTN case correct? As I say, it has received a little bit of criticism, but at the end of the day, all that needs to happen is that MTN must just demonstrate that the vouchers that they are issuing are more multi-use vouchers as opposed to specific use vouchers. And that would then make all the difference. Yeah. Okay. All right. Yeah. So very interesting. Oh, good. I found a way to clear these things off my screen so that I can read the next slide. No, it's still there. Okay. Anyway, let's go on to the next case. And the next case. Oh, I see there's something come up in Q&A. Let me just see. Sorry, I'm not able to open this Q&A. Danny, I don't know if you can open it if you want to open it.
Sorry, is there a time limit to require to the declarations of dividends to the trust?
Not that, no, not that I'm aware of. No. Because I mean, if in the ordinary circumstance, if you have a company with shareholders and you have a company distributing profits go through to the shareholders by way of dividend. If one of those shareholders happens to be a trust, I'm not seeing how that would change the situation. Yeah. Okay. Sorry, I just want to see if I can somehow get rid of this because now it's just blocking my slide here. Yeah. This is really.
Is it no possible to minimize it?
Yeah, I'm trying that. Hold on a sec. Delete. Delete, delete, delete. Still leaves me with this little sort of flag here. But anyway, I will work around it and I'll just sort it out during the break, not to worry. Okay, let me just put this back onto presentation mode. Okay, all right, so Rapper Resources. Here we had a case where we had, and this has become quite a topical case, dealing with SARS refunds and of course the perennial problem that many taxpayers have around getting those refunds paid out. And in fact, this particular case was a case where the taxpayer had actually involved the tax ombudsman. And so it's also interesting to just see that involving the tax ombudsman can have quite a positive outcome. Because I know sometimes people say, oh, you know, they've tried making use of the tax ombudsman and they've just got no joy. But actually, I think we are seeing more and more that the tax ombudsman does have a bit of clout and they do follow things through. Now, in this particular case, they actually assisted with this taxpayer taking this matter through to the High Court. This is a Gauteng High Court case. And it was where the SARS had simply refused to pay out VAT refunds. Now, Rapper was involved in the gold business and they were trading in gold bars, gold and other precious metals. And all of their sales were exports. Okay, so you know the story here, when you have a vendor where all the sales are exports, you are claiming input tax credits, but there's no output tax. So every VAT return is resulting in a refund. Some of you deal with this. And then what you know, like, is every VAT return results in a refund, which translates into an audit, right? And so then this taxpayer was notified by SARS that it was indeed being audited. This was for the February or March VAT period. And so SARS stopped the payment of the refund while the audit was taking place. Now, that is permitted in terms of the Tax Administration Act, that the refund may not be paid out while there's an investigation, audit, or criminal investigation until that has been completed. But the issue is, how long must an audit take? So first of all, in this case, what was the basis of the audit? SARS said that there was reason to believe that the kind of business that R was in was typical of businesses that they had seen being involved in unlawful activities. And so they said there's a strong risk that this could be, this refund could be linked to unlawful activities. And so they didn't want to pay out the audit until they had satisfied themselves that there was nothing untoward about this refund. Okay, so, but then what happened is that these refunds were withheld from 2020. And if you look back, what I said here is that this judgment was handed down in November 2020. So from February all the way through to when this went before the High Court in November. So some 10 months. Now, many of you are sitting there saying, okay, this is not surprising. We see this kind of thing all the time. The total amount of refunds withheld during just from February, March, April, May, June, 5 months was about 1.6 billion rand. And RAPA contended that it would not be able to function without those refunds. I mean, yeah, I can imagine that for many businesses, even if it's not 1.6 billion, it's all relative. So even for smaller businesses, their businesses can also be threatened and jeopardized where there's constant withholding of refunds that should be paid out to them. All right, so in this particular case, RAPA argued that they had an urgent matter because of the size of the refund and the fact that it was prejudicing their business. And their bank had also terminated their overdraft facility, and they needed that overdraft facility. Okay, especially because of the downturn in business with the COVID pandemic. All right, so RAPA had provided all the requested information to SARS by the 9th of July. Then SARS requested further information on the 31st of July. They provided that on the 11th of August. So there was never any contention that SARS required further information. All the information had been provided. Okay, so the issue is that SARS, as you can imagine, every tax period that came up, there was another audit. Then they kept asking for more information, which translated into another audit. And this just went on and on and on, as I say, for 10 months. So the key question is, how long should an audit go on? It should be a reasonable period of time. There's no specific time frame given in the Tax Administration Act, but it must be a reasonable time frame. So the judgment here said that SARS must be afforded sufficient time to carry out the audit and to ensure that the information provided by the taxpayer does not support a conclusion that they are complicit in an unlawful scheme. So the taxpayer had said, they'd gone to the court asking for an order to SARS to pay out the refund within 15 days. The judgment was that 15 days was too short, but what would a reasonable period of time be? And so they went on to say that taking into account that SARS did have all the necessary information, they've had that since August, and here we are now in November, and that any further information requested may only supplement a process already well underway. They were satisfied that SARS could be allowed until the 11th of December, which is about 5 weeks from the date of this judgment, to the 11th of December to finalize the audit and make payment of the refunds, unless there was an outcome from the audit that indicated that the payment should not be made. And they said this must include the audit of all refunds withheld until the date of the hearing, because the argument was that subsequent audits were necessary because if something was wrong with the March period, then the issue would continue into the following period. So the judgment here was basically saying to SARS, you've got a fixed period of time now until the 11th of December to finalize your audits and pay out the refund, emphasizing the point that audits cannot just drag on and on and on. There must be a date when the audit is finalized, and that should be a reasonable period of time. But as I say, unfortunately, we don't have the certainty in the Tax Administration Act of specifying what that reasonable period of time should be. I think it's going to be impossible to put that kind of thing into the Tax Administration Act because every audit is different. I'm sure you can appreciate that. And so it's very difficult to put a fixed time period. But the key thing is that SARS must not abuse their powers by dragging our audits on. And that's a key point that came out of this judgment. The conclusion of the judgment was that there's no reason why costs should not follow. So here we see that costs, so the judgment went in favor of the taxpayer and costs followed the judgment. So SARS was directed to pay costs. They were instructed to pay out the refunds. Oh, and the other important point in this judgment was that SARS was arguing that even if security was provided, unless the taxpayer could come up with security equal to the whole amount of the refund, then no portion of the refund could be paid out. And the court disagreed with that. And they said, if the taxpayer is able to come up with, let's say, 20% of the refund by way of security, then pay out 20%. So to the extent that you can provide security, the refund should be paid out. It mustn't be a case that you get no refund until you are able to come up with security for the full amount. Okay, so SARS was instructed to complete the audit and pay out the refund and to pay the costs of this application. It's quite an important outcome for the taxpayer, but actually important for all taxpayers and for SARS, because it emphasizes, as I say, the focus of the tax ombudsman in addressing these systemic issues, which includes refunds, and it includes things like the objection appeal process and so on. And the tax ombudsman takes these things very seriously, and also indicating to SARS that they cannot abuse their position, and they certainly would not get the approval of the courts to do that. And taxpayers can take these matters on review, and they can take these matters to the High Court. The problem is that it's expensive to do this, right? But at least they did get an outcome instructing SARS to pay out by a certain date. Yeah, so a very interesting outcome there, and I think does give us all a little bit of glimmer of hope when it comes to dealing with refunds and audits. Right, and then on to the next one, also kind of a tax administration related case. So this particular case, Medtronic International, and it's basically looking at, sorry, just close that, looking at a situation where there was a voluntary disclosure program. So in this particular case, now it's quite interesting, Medtronic, you can see a Medtronic International trading. So it's actually an international business, and they provide medical equipment. They have been quite involved during the COVID era with providing PPE and so on. But of course, they've been around for quite a long time. Now, this harks back to a rather sad story that I'll come to just now, but as a result of which the taxpayer applied for the voluntary disclosure program. And they entered into a voluntary disclosure agreement with SARS, which gave them relief from criminal prosecution, and it gave them relief from penalties, but it didn't give them relief from interest, and it didn't give them relief from the capital sum. Now, it's understandable about the relief from the capital sum. That tax would still be owing. But what happened is that after the voluntary disclosure agreement had been signed, the taxpayer then pursued the issue around the remission of interest under Section 39(7) of the Value Added Tax Act. They said they still had a right for the commissioner to consider their application, their request for remission of interest. The commissioner took the view that because they had entered into a voluntary disclosure agreement, that agreement took precedence over the ability to apply for remission of interest under Section 39. So it kind of wrapped up and established a tax liability, and that was then the final tax liability according to SARS. Whereas the taxpayer said, we might have a liability under the VDP, but we still want you to go and look at this request for remission of interest that we made under Section 39 of the VAT Act. Okay, so basically this is what the application to the High Court revolved around. Now, let's just go and have a look at the facts behind this case. So what happened is that this taxpayer, the bookkeeper, had defrauded the taxpayer between 2004 and 2017. So for 13 years, the bookkeeper had defrauded and falsified tax returns, as a result of which there was a significant understatement of VAT to SARS. And so when you look at the amount involved in the voluntary disclosure agreement that had been agreed to with SARS, it involved a capital sum of VAT to the tune of 286 million rand and interest to the tune of 171 million. And there was also penalties of 172 million. So if you add all of that together, the original liability would have been like 600 million rand owing to SARS. Massive, absolutely massive. Now, the penalties, as I say, were waived as part of the voluntary disclosure relief. But when you look at the voluntary disclosure provisions in the Tax Administration Act, it is silent on the question of interest. So it doesn't speak about interest at all. What it talks about is giving relief for criminal prosecution and relief for penalties, right? Understatement penalties and most administration penalties, but not penalties for failure to submit a tax return. All right, so the fact that the voluntary disclosure agreement had been entered into, the taxpayer still applied to this High Court to instruct SARS to respond to the application for a remission of interest. They had applied to SARS for a remission of interest under Section 39(7) of the VAT Act, read together with interpretation note number 61. SARS refused the request. The taxpayer then raised an objection in December 2018, against SARS' decision to refuse the request for remission of the interest. And SARS disallowed that objection in March 2019. And they said that the agreements entered into, the voluntary disclosure agreement, basically overshadowed anything else. And so that request for the remission of interest, as far as SARS was concerned, was water under the bridge. It was null and void because it had been overtaken by the voluntary disclosure agreement. And so as a result of that, the taxpayer launched these review proceedings under the Promotion of Access to Justice Act. All right. Now, the taxpayer testified that they had requested SARS to waive the interest in the course of the VDP discussions, and the VDP unit had responded that SARS would waive all of the penalties, but it did not have the authority to waive the interest, because, as I say, the VDP provisions are silent as to interest. So the VDP unit of SARS does not indeed have the authority to waive the interest. But the fact of the matter here is that the taxpayer was arguing that they had the other route going through Section 39(7) of the VAT Act. They were appealing under that provision for the interest to be waived. SARS contended that it agreed with the applicant that it would give relief for the penalties and it would still keep the liability for the interest. But the taxpayer persisted that they were entitled to a waiver of interest under Section 39(7) of the VAT Act, read with interpretation note number 61. All right, so let me just tell you what Section 39(7) of the VAT Act says. So what is also interesting, of course, is that this provision of the VAT Act dealing with interest is still relevant. It hasn't been overtaken by the interest provisions in the Tax Administration Act. What this particular provision says is that where the Commissioner is satisfied that the failure on the part of the person concerned or any other person to make payment of tax within the period prescribed, so failure to pay by due date, basically, if that was due to circumstances beyond the control of the person, then SARS may remit. Or it was not due to any intent not to make payment of the tax, then the Commissioner can remit any penalty payable in terms of the section. So as far as interest was concerned, the interest could be remitted if the late payment giving rise to the interest was due to circumstances beyond the control of the taxpayer. And interpretation note number 1 deals with this question of what do we regard as circumstances beyond the control of the taxpayer. The key thing was that SARS, as far as they were concerned, the taxpayer had no right to persist with this argument under Section 39(7) because they said that had been overtaken by the VDP agreement. But the taxpayer argued that they still had a right to request the remittance of interest under Section 39(7). So the question of whether SARS may consider a request for remission once you've entered into a VDP agreement comes down to the interpretation of Section 39(7) and to an extent the interest provisions of Section 187 of the Tax Administration Act. And so going into some discussion around principles of interpretation, etc., the conclusion of the court was that the provisions of Chapter 16 dealing with the voluntary disclosure agreement and programs does not prohibit a request for remittance of interest under Section 39(7). So even if a VDP agreement has been entered into, that doesn't prevent the taxpayer from making use of the internal remittance provision, which in this case is Section 39(7) of the VAT Act, to request a remission of interest. So notwithstanding that there was a VDP agreement that had been entered into, SARS, the respondent, had a statutory duty to consider, adjudicate, and decide on a request for the remission of interest in terms of Section 39(7) of the VAT Act. So in other words, that request for remission of interest was still valid. It was still available to the taxpayer. And I think this addresses quite an important point as far as voluntary disclosure agreements are concerned, because it certainly points to the fact that the remission of interest is still possible in terms of the internal interest remittance rules of the relevant tax legislation. So the fact that you have a voluntary disclosure agreement does not overtake that and render a remission of interest impossible necessarily. Now, of course, SARS wasn't terribly happy with the outcome of this case, and they yeah, well, it would seem that they would want to take this matter on appeal, or they might want to change the wording of the voluntary disclosure provisions in the Tax Administration Act. It remains to be seen what's going to happen with that. Okay, I'm going to just stop there. I think we're just about ready to take our break. And so I'm going to suggest that perhaps we do that now. And if you have any questions, send those through. We'll take a 15-minute break until 3:30. Okay, thank you.
That's great. Thank you.
I didn't get that. Could you try again?
Right. Hi, everybody. Back again. Hope you're all ready to carry on for the second session. And let's get straight into it. Okay, so we had ended off talking about the Medtronic case and making the point that even with a VDP, because the VDP doesn't specifically prohibit a taxpayer applying for remission of interest, that the remission of interest application was valid and that SARS was obligated to consider it. Okay, then let's go on to the next case. There's two more cases to deal with. Abso, this is Abso and another versus SARS, and this was a High Court judgment also from the Gauteng High Court handed down on the 11th.
Do you want to quickly do the one question? There was a question about the Massmart.
Oh, I didn't see that. Okay, thank you. In the Massmart case, if the company was the vested beneficiary in the shares, then any gain made by the trust will be disregarded, deemed to be no. Okay, so as I say, yes, that was the case that they were the vested beneficiary of the capital gains, but that doesn't apply to capital losses. Capital losses cannot be vested in a beneficiary. So when you look at capital gains are either taxed in the trust, or if the beneficiary has a vested right to the capital gain, taxed in the hands of the beneficiary under paragraph 80. But paragraph 80 only refers to capital gains, not capital losses. So the capital loss stays in the trust. Okay, so let's go on. Thanks for bringing that to my attention. Just make sure there aren't any others that I've missed. Okay, that's great. Right, so let's go then and have a look at Abso Bank. So Abso Bank, as I say, High Court case, heard in March 2021. The summary on the SARS website talks about whether the taxpayer is allowed to approach the High Court for a review of a SARS decision, or if they have to go through the dispute resolution process as per the objection and appeal process set out in the Tax Administration Act. Now, in this particular case, the taxpayer was involved in various transactions. SARS was of the view that there was an impermissible avoidance arrangement under the GAR provisions of Section 80A through to L set out in Part 2A of the Income Tax Act. And so what had happened is that SARS had raised a notice, Section 80J, on the taxpayer, notifying them that they were going to apply the GAR provisions. And of course, that would mean that they would raise an additional assessment on the taxpayer. The taxpayer did raise an argument as to why the GAR provision should not apply, but notwithstanding, SARS went ahead and raised the additional assessment. So the issue was whether now the taxpayer had to go through the objection appeal process in relation to that objection, or could they just ask the High Court to review that action of SARS? And so that was the one issue, but the real crux of the matter was whether in fact there was an impermissible avoidance arrangement and whether Abso Bank was a party to this arrangement. So if there was no impermissible avoidance arrangement, then of course the additional assessment raised by SARS would have no force and effect. So Abso was actually looking for a review of two decisions made by SARS. The one was SARS' refusal to comply with the request by Abso to withdraw the Section 80J notice. Okay, so that notice had been raised. Abso had provided a counter argument as to why it should not apply and requested SARS to withdraw, but SARS had not complied with that request. Instead, they went on and raised this additional assessment, applying the GAR provisions. All right, the other decision made by SARS was to issue these letters of assessment to the taxpayer in respect of this additional tax liability. In other words, applying the GAR provisions and then raising the additional assessments. So it was the 80J notice and the additional assessments, basically. Those decisions, those actions by SARS that Abso was asking the High Court to review. So it's quite an important point that the taxpayer taking the matter on review to the High Court, as opposed to just objecting to the assessment, because obviously going the objection and appeal route could be quite time consuming, whereas applying to the High Court for review, you would get a decision and hopefully the decision going in the taxpayer's favor. But in the course of coming to this decision, in terms of reviewing the SARS decisions, as I say, the crux of the matter was whether there was in fact an impermissible avoidance arrangement and whether Abso was a party to such arrangement. Now, if you look at Section 80A through to L of the Income Tax Act, looking at an impermissible avoidance arrangement. So a tax avoidance arrangement is where there is a tax benefit, okay? And an impermissible arrangement is when there's a tax benefit and basically in the context of business, it was entered into or carried out in a means or manner which would not normally be employed for bona fide business purposes other than obtaining a tax benefit, or it lacks commercial substance. Now, if you look at this series of transactions in which Abso was involved, they were actually only involved in this first level of the transaction. They had subscribed for preference shares in another resident company, PSIC3. That resident company had in turn used that capital to invest in preference shares in another resident company called PSIC4. So the one company investing in the next and that company in the next. PSIC4 had then, and this is where things may start looking at possibly a tax avoidance arrangement, if it is that, but they then took that capital and invested it into an offshore trust called the DI Trust. And the DI Trust used that capital partly to repay loans to a South African subsidiary of an Australian holding company. So they had loans basically that those were repaid. And initially, when Abso took up these pref shares in PSIC3, they were of the understanding that there would be a back-to-back arrangement where that capital would be used to repay those loans. So that was what they saw as the ultimate outcome of that. But they were not aware of the intervention of PSIC4 and the DI Trust, and the fact that the DI Trust would use some of that capital to invest into Brazilian bonds. Now, the issue here, investing into bonds issued by the Brazilian government, now that interest on the Brazilian bonds would be taxable only in Brazil under the double tax agreement. And as it turns out, in Brazil, they have an exemption for such interest. So that interest was earned basically completely free of tax. So maybe there would be an argument to say that there would be more interest paid through than would otherwise be the case if tax had been paid. And so that interest then went through to PSIC4, and it was not taxable. Maybe the argument would be that that would result in more dividend being paid. But if you think about it, it's a dividend going from a resident company to another resident company, so totally exempt from both income tax and dividends tax. And then certainly the dividend going from PSIC3 to Abso, again, a dividend going from resident company to resident company, no dividends tax or income tax. So some people would say it's difficult to see where the tax benefit is. If anywhere, it could be down here where there's this interest earned free of tax that's flowing through to PSIC4. But the question is then, so is there an impermissible tax avoidance arrangement? And is Abso a party to an impermissible tax avoidance arrangement? Now, Abso testified that they had no knowledge of these further investments down the road here. They knew about their investment in PSIC3, investment in preference shares. That's a pretty straightforward transaction, earning dividends that would be entirely tax-free. So basically, the conclusion was that there was nothing to establish that Abso was a party to a tax avoidance arrangement, nor that it had any intention to escape an anticipated tax liability, and it had not received relief from a tax liability as a result of acquiring the preference shares in PSIC3. Now, the letters of assessment then raised by SARS alleging there's an impermissible tax avoidance arrangement and Abso is a party to that. So then raising the additional assessment. So first of all, the notice and then the additional assessment basically had no force and effect, because the outcome was that there was no tax avoidance arrangement, certainly that Abso was not a party to such an arrangement. But what is interesting with this case is that it does lay down some important principles around the general anti-avoidance rules. And we have not really had any judgments that have given us guidance on the interpretation of the new legislation. Of course, we had a few cases skirting around the issues on the old Section 103, but certainly not on the new GAR provisions, or not so new anymore. I mean, they've been around for quite a long time, but we certainly haven't had any judgments. And so the outcome of this case and this judgment is important in terms of giving us some guidance on the interpretation of these provisions. So in a recent PwC synopsis, which I've borrowed from here, basically, and given them credit, there are 5 important points that come out, principles of this case. The one is that when we talk about an impermissible tax avoidance arrangement, so an impermissible tax avoidance arrangement, as I say, is an avoidance arrangement that basically has this aspect of being entered into in a way that would not normally be done for business purposes, or it lacks commercial substance. When we talk about an arrangement, we're talking about a whole series of transactions, and avoidance arrangement means that that collection of transactions results in a tax benefit. Now, one of the principles of this case was that a series of transactions in themselves doesn't constitute an arrangement. So the fact that we had this series of transactions, as I've depicted here, in itself, that doesn't make an arrangement unless there's something that interlinks or provides some kind of unity between those transactions. All right, so that in itself doesn't constitute an arrangement. And the fact that Abso was party to one transaction in that chain of events does not, without something more, result in Abso being a participant or taking part in an arrangement. Then, of course, the other thing is, what is the purpose? The purpose of tax avoidance must be established subjectively by reference to the taxpayer, not just by looking at an arrangement that results in a tax saving. There must be an intention, a purpose, to actually enter into this arrangement with the purpose of avoiding tax. And when we look at whether tax has been avoided, you would look at the but-for test. So if the taxpayer proceeded along this route that they are on, they would have a tax liability, but they enter into an arrangement. So but for this arrangement, there would be a tax liability, but they enter into the arrangement, which takes them on a different path that avoids that tax liability. So that's how we would indicate that there would be a tax avoidance. If a person would not have incurred a liability to tax through entering into the same transaction in other circumstances, it's difficult to assert that the person has derived tax benefit. Now, in this case, Abso invests in preference shares, earns tax-free dividends. So where is the tax benefit there? All right, they weren't on a path where they would have to pay tax and they suddenly deviated. So it's not that they would have incurred a liability but for that arrangement. So in this particular case, it does give us some principles around the interpretation. So what is GAR? What does it stand for? It stands for the General Anti-Avoidance Rules. It's just a term really that's come about, but it's these provisions that sit in Part 2A of the Income Tax Act, sections 80A through to 80L. And basically it looks at when do you have an impermissible tax avoidance arrangement. And then all these provisions go into deciding when you would have an impermissible avoidance arrangement, and then also saying that if you do have an impermissible avoidance arrangement, the commissioner can then notify the taxpayer that they're going to apply Section 80B. And if they apply Section 80B, then they can basically assess the taxpayer as if they had not entered into that arrangement. Okay, right. All right, so that's that question answered. Let me just see if there's any others. Sorted. Okay. Right, then let's look at the Wenco case, last case we're going to talk about today. I know this has been a bit of an overload of judgments, but it's just interesting that we've had so much coming through the courts. In this particular case, again, a VAT case. And we are talking about a situation where we've got an overseas company that is carrying on business in South Africa through a branch. All right, it's not a subsidiary, it's a branch that is operating in South Africa. They had applied for a SARS ruling to confirm that the South African branch should register for VAT. SARS basically said, well, no, they don't agree with that. They think that it is the head office, the overseas company, that should register for VAT. And so they applied to the High Court again for a review of this decision, whether SARS should be directed to issue a VAT ruling allowing the branch to register for VAT. And then also linked to that, if the branch registers for VAT, basically all of the supplies of the branch are made to the head office. So a ruling that basically they would account for the zero rate on those services rendered to the head office. So the setup looks something like this. You've got Wenco Canada, so international company, established in Canada, head office operates there. They develop software for the mining industry, and they supply their clients with management system software, maintenance, safety, and machine guidance to manage mining operations. They then have clients in Africa, as they do all around the world. But they set up the South African branch to service the South African clients. So the South African branch provides services in the form of training, system support, site visits, and installation. And that is for South African and other African clients of Wenco Canada. Now, all the services of the South African branch are actually registered by the branch on behalf of the head office in Canada. So if we go back here, I've said all the contracts between Wenco and the clients are concluded and signed in Canada. So that's really where the business is based. The South African branch just does the legwork in terms of the training, system support, and so on. So they service these clients in Africa on behalf of Wenco Canada. Now the question is, so who registers? Is it the South African branch or is it Wenco Canada? Now, if you think about it, if Wenco Canada registers as the vendor, what supplies are they making? All of their suppliers constitute charges to their head office, and it's a management fee that comes through. So that would be zero rated, okay? And they would be claiming all of their input costs. If it was the overseas operation that had to register, they would be registering on the basis of carrying on an enterprise in the Republic. And so all of their fees that are charged basically to the South African clients certainly would carry VAT at 15%. Assuming that they don't have any costs, they would not be able to claim any input tax credit. All right, but if they did have costs related to that, then they would have an input tax credit that they could claim. But you can see it would be a significant difference. 15% VAT, output VAT versus zero rated supplies. Okay, so, and the court did take this into account in their judgment. They did consider what would the outcome do to our South African tax base. Now, basically, they're looking at the obligation to register requires that a person must be carrying on an enterprise in the Republic. And the taxpayer, the vendor, was looking at Section 8(9) of the Act, which basically says that if you've got a head office and a branch carrying on, and there's an independent accounting system, then the branch is regarded as independent, but that presupposes the existence of an enterprise. Okay, so if the branch was actually carrying on an enterprise, then there might be a question around, because the branch did have a separate accounting system and so on, then there might be an argument around the branch being the vendor that would have to register with SARS. But in this particular case, it was held. Oh, and the other point of Section 8(9) is that if that is the case, that it's carrying on an enterprise, then any supplies that it's making to the head office would be regarded as supplies made to an independent person. Now, the thing is here, it presupposes the existence of an enterprise. Is this branch actually carrying on an enterprise in the Republic? Now, the outcome of this case was that actually all the branch is doing is it's acting as an agent for the head office. And so everything it's doing is actually on behalf of the Canadian head office. And therefore, it should be the Canadian head office that has to register, not the South African branch. So the application of the taxpayer dismissed with costs, including the costs of to counsel. Now, it has kind of thrown things up in the air a little bit because we do have a lot of these types of setups working. And it seems that the general modus operandi was to register the South African branch as a vendor. This seems to be going against that. So it's going to be interesting to see what comes out as a result of this. Will this matter go on appeal and have a different outcome, or will there be some clarity brought from SARS in terms of the obligation to register and where that obligation actually sits? But you can see that when there's such a different outcome in terms of the VAT situation, standard rated versus zero rated, it would seem that it would tend to sway on the side of looking at the international head office as being the vendor that has to register. And then all of the supplies that are made in South Africa certainly would have to carry VAT at the standard rate. Okay, that's the end of the discussion on the cases. Let me move then on to the SARS documents and notices. I'm going to talk about the 21 filing season, the SARS notice on rental income, and then some recent interpretation notes. Okay, so just note that interpretation note number 14 has been updated. That deals with advances, reimbursements, and allowances. It's been updated for the amendment dealing with the reimbursement of expenditure when a person travels for business just for within a day, not overnight. So it's just been updated with that amendment that came through from the 1st of March this year. Also note that the interpretation note number 12 dealing with recoupment assets in a deceased estate, of course, the tax treatment in a deceased estate has changed, and so that interpretation note has been withdrawn. And I'll talk briefly about these other interpretation notes later. All right, let's have a look at the 21 filing season. So the filing season will open on the 1st of July. SARS has published their annual notice in which they indicate who has to submit a tax return. That notice was published on the 14th of May. I'm not going to go through the whole notice, but just to make the point that you remember there's always that exemption for individuals who earn gross income from one employer. And this exemption will apply when your gross income consists solely of remuneration from one employer not exceeding 500,000 Rand, and the employer has been correctly withheld. The employee's tax has been correctly withheld by the employer. All right, so the remuneration threshold of 500,000. And in addition, your other sources of gross income is interest, which is fully exempt, dividends going to a non-resident, and then amounts from a tax-free investment. So in other words, you don't have any other taxable income. You've only got remuneration. It comes from one employer and it doesn't exceed 500,000, and the employer has withheld the correct amount of employees' tax. And note that when we talk about remuneration, without any fringe benefits or allowances, because as soon as you have an allowance, then of course the indication is that you'd be claiming a deduction, for example, against a travel allowance, and you would need to be submitting a tax return in order to do that. Okay, SARS will be using the auto assessment process again this year, like they did last year. And there is the exemption that if a person is notified that they're eligible for auto assessment and the person confirms that their information is correct, then they would not have to submit a tax return. But you need to reply to SARS SMS when they put out the auto assessment. It's when you accept that the information is correct, then you are eligible for the exemption. You don't have to submit a tax return. But if you ignore the SARS notice on the auto assessment, then the assumption is that you do have the obligation to submit a tax return. And if you fail to submit, then SARS is going to raise an estimated assessment. Okay, so this filing season will then open on the 1st of July. Deadlines for submission, non-provisional taxpayers will be the 23rd of November, and provisional taxpayers will be the end of January next year. There has been a revised ITR 12 return, which has gone out to all the RCBs for comment. Comment has been submitted, and so I think everything is good to go for release of the tax return comes the 1st of July. So good luck with all of that to get through the filing season. Of course, we currently are still in the season of the EMP 501 reconciliations. Those are due to be submitted by the 31st of May, which is Monday next week, right? So that deadline is looming. Please be careful, and please warn your clients to be careful to make sure that they do submit by the 31st of May, because SARS will be levying this penalty for late submission. It is a penalty of 1% of your PAYE for the year. It's 1% of that for every month that the reconciliation is outstanding, and it's it's an incomplete submission. Okay, and that can go up to 10% of PAYE, but it doesn't end there, because it can even lead on to criminal prosecution. So an employer who willfully or negligently fails to submit an EMP 201 or 501 is guilty of an offence and liable upon conviction to a fine or imprisonment for up to 2 years. So it's extremely serious to ensure that these returns are submitted correct and complete. Okay. Notice, of course, that there was the SDL holiday from May to August, and that needs to be correctly reflected on the EMP 501. that you show a nil SDL for those particular months. Otherwise, you're going to end up with additional liability with penalties and interest. So make sure that that is correct. Okay. Of course, I think many of you might have seen this notice that SARS released on their website on the 11th of March, warning people to declare their rental income. In previous years, prior to the COVID era, many people, more and more so, were getting involved in Airbnb, renting out properties and so on. And the concern from SARS is that people have not always been declaring income. Even if you rent out a garden cottage, even if you rent out a room in your house, you are earning income, and that rental income should be declared. Of course, you might be eligible for certain deductions, and you would take those deductions into account. But the important thing is that the income with the related deductions, it's a trade that is being carried on, and that must be declared to SARS. Okay, and they make a point also that if you have not declared in previous years, you could regularize your affairs, making use of the voluntary disclosure program. Okay, then on to the interpretation notes. So a new interpretation note issued in March 2021 was Interpretation Note 114, dealing with trusts and beneficiaries and looking at the interaction between 25B and Section 7.8. Perhaps let me just go to that Q&A. Where's my cursor? Okay. It's grayed out. This might be something that they've done now, that you are unable to record the nil amounts because it's grayed out. But just be careful that whatever you do submit related to the SDL for those months is correctly recorded as being nil. If you're able to do that, of course, if they've graded out, I don't get involved in submitting EMP 501, so I'm not aware of that, but just be careful that you do declare it correctly. Okay, so back to Interpretation Note number 114. So the issue here is that when we look at the way in which trusts and beneficiaries are taxed, and I mentioned this briefly earlier, that remember, a trust is a person capable of being taxed in its own right. We have tax rates that apply to trusts. And so if you have income earned by a trust or a capital gain earned by a trust, first port of call is that it will be taxed in the trust, unless there is a provision that causes that income or capital gain to be taxed not in the trust, but in the hands of perhaps a donor or in the hands of the beneficiaries. Now, Section 25B1 talks to the taxation of trusts and amounts accruing to trusts. It used to talk to income accruing to trusts, but the wording of that was changed. But in essence, it is intended to refer to income. We've had a recent tax court case that looked at the question of whether it can also apply to capital gains. And the conclusion was that it doesn't. Well, SARS argument, it was slightly different in the court, but SARS argument and in the comprehensive guide is that it doesn't apply to capital gains, it only applies to income. But nonetheless, we're not talking about capital gains here. We are talking about items of income. So if you've got an amount of income that has been earned by a trust and the income has been earned as a result of or in consequence of a donation, settlement, or other similar disposition, then of course you've got Section 7 that could apply. And Section 25B applies subject to Section 7. So Interpretation Note 114 is a little bit of a technical interpretation note, basically saying that if you have conflict or inconsistency or incompatibility, then how do you approach this? And basically it must be that Section 7.8 in this case, income accruing to a non-resident in consequence of a donation, settlement, or other disposition made by a resident. So there, Section 7.8 would apply first before you consider the application of Section 25B. And so the rationale for the interpretation note is that these provisions are not being applied correctly by taxpayers, and they wish to correct this. And they say when there is conflict, inconsistency, or incompatibility, and they say that can occur when an amount received by or accrued to a non-resident discretionary trust as a result of a donation, etc., by a resident, which would have constituted income had that non-resident been a resident, then that's vested in a beneficiary, then how do we treat that? We could have conflict in terms of the fact that we say Section 7.8 causes that amount to be taxed. It deems the amount to be received by the South African donor, but Section 25B requires that amount vesting in a beneficiary should be then taxed in the beneficiary's hands. And so they say this could lead to conflict. Let me just show you a little diagram, then I'll come back to that slide. So you've got the resident donor who's made a loan, interest-free loan for argument's sake, or a donation to a non-resident trust. That amount, that capital has been used to invest in income earning assets. The income comes into the trust. That income, if that trust was a resident, it would be taxed, it would be subject to tax. Section 7.8 requires that their income is then taxed in the hands of the resident donor. But then we've got section 25B that says income is taxed in the trust unless the beneficiary acquires a vested right to the income in the same year of assessment, in which case the income is taxed in the beneficiary. So how does this work? Well, the answer is that section 8 takes precedence over section 25B. And so you would deem the income to accrue to the donor, taxed in the hands of the donor, then there'd be nothing to tax in the hands of the beneficiary. So that's the short version of what section 114 is, interpretation note 114 is actually saying to us. They do give an example. So let's say, using this little description over here, if the donor had lent R1 million to the non-resident trust at the beginning of the year, and the trust then invested that money and earned interest at 10% per year. Sorry, 12% per year. If the trust had borrowed that R1 million, it would have paid a market-related rate of 10% per year. All right, but in actual fact, it's paying nothing on the loan from the SA resident individual. So it's an interest-free loan, but then the trust uses the money to invest in a foreign bond on which it earns 12% per year. So you've got interest income of 12%. And then that 12% on R1 million, 120,000, the trustees took a decision to vest that amount in the beneficiary, who is a resident. So it's exactly this scenario. So the trust borrows the money, invests it in foreign bonds, gets interest of 120,000. The trustees decide to vest that amount in the resident beneficiary in the same year in which it arises. But the point of the matter is that the 120,000, or at least part of that, was earned in consequence of a donation, settlement, or other disposition, because there was this interest-free loan. Okay, so by way of interest, the SARS official rate of interest is 4.5%. So how much of this 120,000 was earned because of the fact that there was an interest-free loan? If we go to the Woolwich case, it basically says you must look at the market-related interest rate on that loan, which would have been 10%, and then compare that to the interest actually paid, which is nothing. And so you've got an interest benefit actually of 100,000 Rand. The trust has earned interest of 120,000, but only 100,000 is due to the interest benefit derived on that donation, settlement, or other disposition, which is the interest-free loan. So if the trust had paid interest on a market-related rate, it would have paid out 100,000. It would have got in 120,000. It would only have had 20,000 Rand available to distribute. Okay, so it's got an additional 100,000 Rand because of the fact that it got this interest-free loan. And so it's this 100,000 Rand that has been derived in consequence of the interest-free loan. And it's that 100,000 then that is subject to section 7.8. Section 7.8 provides that that 100,000 Rand is deemed to accrue to the donor. And so it'll be taxed in the hands of the donor. The trust received 120,000. 100,000 goes back to the donor. It leaves 20,000. And so section 25B can only apply to the 20,000. So even though the trustees have distributed 120,000 to the beneficiary, there's only 20,000 that can be taxed in the beneficiary's hands under section 25B, because section 7.8 has diverted 100,000 already to the donor, and you can't have both amounts being taxed. Okay, so you wouldn't apply both. Section 7.8 applies first, and then section 25B applies to the excess. Of course, in this particular scenario, you might say, well, what about section 31? Do we have to do a transfer pricing adjustment? Now, section 31 talks to a situation where you have what they call an affected contract. And that's a contract that is between resident and non-resident in essence. They are connected persons, and there is a tax benefit. All right. So here we have got a resident and a non-resident, and there are terms and conditions that you'd not normally find in an arm's length transaction because you've got a loan carrying 0% interest. And there is a tax benefit because if the resident had charged a market-related interest rate, it would have earned interest income. It would have been taxed on that interest income. So there is potentially a tax benefit, but is there really a tax benefit? Because although there would have been the case that there would have been income had the loan carried interest at the market-related rate of 10%. But in fact, we've already adjusted for that through the Section 7(8) adjustment. So after the 7(8) adjustment, there's no longer a tax benefit because now we have taxed that amount in the hands of the resident lender. Okay, so there's no resulting tax benefit. And so then there would not need to be a Section 31 adjustment. Leads us on to the old question, or not so old, but the perennial question of Section 7C. Do we have to apply Section 7C to this loan? Because we've got a loan that has existed between the donor and the trust, and let's assume that they are connected persons because the beneficiary of the trust is the child of the lender. So there's a connected person situation. So there's a loan that's gone to a trust. It's carried interest at less than the SARS official rate. Now, important, notice here it talks about the SARS official rate, whereas previous provisions, Section 7(8) and Section 31 looked at the market-related rate. Here we look at the SARS official rate. So here we look at the interest benefit being the difference between what would the interest have been had we charged interest at the SARS official rate of 4.5% versus what was actually charged, which is nothing. And so there is an interest benefit of 45,000, which is deemed to be a donation made by the South African resident. And so that would be a Section 7C deemed donation, and there would be donations tax that would arise on that. Now you might say, but hold on, Section 7C does not apply when Section 31 applies. But remember, we just showed on the previous slide that Section 31 does not apply because Section 7(8) has intervened. And so Section 31 does not apply in the situation. And so there's no exemption otherwise from Section 7C. And so you would have a deemed donation that would trigger donations tax. All right, so all very interesting things about loans to trusts and the application of Section 7(8) and the application of Section 25B. Right, and then just quickly on to the other interpretation notes. So interpretation note number 115 deals with the withholding tax on interest. Now the withholding tax on interest is levied in terms of Section 50A, etc., of the Income Tax Act. It sits in what is referred to, I'm just getting the part number, it sits in Part 4B of the Income Tax Act, Section 50A, and it runs all the way through to 50H. All right, now what it applies to is when you've got South African source interest paid to a non-resident, in essence, a foreign person. And the thing is that interest, of course, a non-resident, remember we tax non-residents on South African source income. So if we just look at the income tax laws around this, we would say that a non-resident earning South African source income, that interest that is paid from a South African source is exactly South African source income, so it would come into gross income. But then we've got an exemption in terms of Section 10(1)H that provides a blanket exemption for interest paid to non-residents, except that exemption doesn't apply in two circumstances. The one is where the person has spent more than 183 days in South Africa in the 12 months leading up to the date on which the interest becomes paid, or the other is interest that is effectively connected to a permanent establishment in South Africa. So both of those basically relate to a kind of a physical presence in South Africa. All right, so apart from that, your interest paid to a non-resident would be exempt from income tax under Section 10(1)H. However, withholding tax is a kind of a separate tax, similar to what we see with dividends. We see a dividends tax, which is separate to the income tax treatment of dividends. So in terms of the withholding tax on interest, Section 50B tells us that there must be levied a tax known as a withholding tax on interest calculated at 15% on any interest paid by any person for the benefit of a foreign person. to the extent that the interest is derived from a South African source. So it's a 15% final tax on interest going to a foreign person, applying to SA source interest. To see what is interest from a South African source, you look at section 9.2b in this particular case, and that tells us, section 9.2 tells us income that is from a South African source. Section 9.2b tells us that interest is from a South African source where the interest is attributable to an amount incurred by a person that is a resident, unless it's attributable to a permanent establishment outside the Republic, or it is received or accrued in respect of the utilization or application in the Republic of the credit under an interest-bearing arrangement. All right, so South African source interest going to a non-resident subject to withholding tax, and that's a 15% final withholding tax. Now, the issue is there are provisions in various double tax agreements for that 15% to be lowered in certain circumstances between, well, as provided in some of these double tax agreements. So it is the reality that sometimes it's not 15%, sometimes it's only 5% or 10%, depending on the application of the double tax agreement. The other thing is that there are a lot of exemptions from this withholding tax on interest. For example, any interest paid by the government to a non-resident. So any non-residents holding government bonds, there'd be no withholding tax on the interest paid to those non-residents. Any interest paid by any registered bank or any listed debt. And indeed, it even says any interest that is included in the income of a resident under section 7.8, which we were just talking about just now. So it's interest going to a non-resident, but then it's deemed to accrue to a resident under section 7.8. There'd be no withholding tax on that interest. So there's a number of exemptions that apply. All right, so although we do have this withholding tax on interest, in reality, it only applies to a thin slice in terms of the total amount of interest that is paid to non-residents. Now, if you have a non-resident that is earning SA source interest, that if they're eligible for an exemption or for a lower tax rate in terms of a double tax agreement, then they've got to do the declaration and undertaking, as we've become used to seeing under the dividends tax rules, that there has to be a declaration and undertaking to state that they are exempt or eligible for a lower rate. And the important thing is that that declaration or undertaking is only valid for a 5-year period. All of these aspects are dealt with in the interpretation note. What do we mean by interest? What do we mean by due and payable, foreign person, etc.? And it explains all the ins and outs. It's a 50-page interpretation note. So if you want to know anything to do with withholding tax on interest, have a look at that interpretation note. I think I saw another Q&A coming in here. Does Section 7C apply to interest-free loans to non-resident trusts? Yeah, Section 7C can apply to any loan, to any trust, as long as there's a connected person relationship. So it doesn't matter whether the trust is resident or non-resident. So if you've got a resident advancing a loan to a non-resident trust, Section 7C can apply. And then, of course, the issue is Section 7C does have an exemption to say that Section 7C does not apply if Section 31 applies. But the key thing is that it must actually apply. It's not just a loan that could fall into the realm of Section 31. Let me read you that exemption, but it actually says specifically that if the loan is subject to the application of the transfer pricing adjustment under Section 31, then it says the loan, advance, or credit constitutes an effective transaction as defined in Section 31 that is subject to the provisions of that section. So if Section 31 applies to that, then Section 7C does not apply. Okay, but otherwise Section 7C very much could apply to cross-border loans. Okay, all right, so that's interpretation note number 115 with a little bit of a Section 7C thrown in there as well. And then interpretation note number 116, very similar, talks about the withholding tax on royalties. So here again, very similar to what we saw with the withholding tax on interest when you've got South African source royalties. And here you look at Section 9.2C through to F. It's talking about amounts paid for the use of intellectual property in South Africa, etc., etc. Royalties paid across to non-residents. They are subject also to a final tax, 15% final tax. There are some exemptions, but they're much more limited. these particular exemptions that apply to the withholding tax on royalties. In fact, the exemptions only apply if the person was physically present in South Africa for more than 183 days, or the property is effectively connected with a permanent establishment in South Africa, or it's related to a headquarter company. So those are the only exemptions. Those same exemptions carry over to the interest withholding tax, but interest withholding tax has a lot more exemptions than that as well. Okay, again, we've got the declarations and undertakings that must be provided if there's an exemption or a lower rate that applies under a double tax agreement. Okay, and then so all these terms, again, that come into play with the application of this withholding tax are all explained in interpretation note number 116. There's also about a 50-page interpretation note. Okay, then the next interpretation note, very recently issued, taxation of the receipt of deposits. And this will take you all the way back to your primary tax studies back at university. You know, when we talk about gross income, any amount received by or accrued to the taxpayer during the year of assessment. Received by talks about beneficial ownership received by that taxpayer on their own behalf, and they basically have entitlement and they can access that amount. So when we talk about a deposit, when will a deposit come into a person, an amount that's paid by way of a deposit? Okay, when would it be regarded as either being included in gross income or not included in gross income? And it comes down to the issue, if the deposit is paid but it's mixed in with the taxpayer's other deposits into the bank account, taxpayer uses that money, etc., then it'll pretty much come into the person's gross income. If a deposit is paid and it's kept completely separate and it's not accessed by the taxpayer, it's kept in a separate account, not touched and kept safe for a refund situation later on, then it's not regarded as received by the taxpayer in the sense of received for their own benefit, and then it would not come into gross income. And so you go back to all the case law around this, and the interpretation note, I'm not going to go into the detail of it, but it says each case must be decided on its own facts. For a deposit to be excluded from gross income on the basis that it was not received by the taxpayer, the amount must not be the taxpayer's money. It must be held separately, kept preferably in a separate account, but even that separate account is not enough. But the taxpayer must actually not touch that money. It must keep it totally separate and not show that it is making use of that money as if it was the taxpayer's own money. Okay, so if it's kept in a trust fund account, it's not the taxpayer's money, it's kept totally separate, the taxpayer can't access it, then it would not come into the taxpayer's gross income. We've had some recent cases, in particular ITC 1918, which looked at basically vouchers, again, sort of amounts that were paid by way of deposit. And there they looked at the Consumer Protection Act and the consequences of the Consumer Protection Act and any obligation that it places on a taxpayer. So those must be considered as well as to whether the deposit must be included in the taxpayer's gross income or excluded. Okay, so it comes really going down to the real foundational stuff, looking at this definition of gross income and the treatment of the taxation of deposits. Okay, so they don't look at capital gains, and they don't deal with amounts deposited with banks, because banks are money lenders. So that's a totally different situation. Okay, so that's the interpretation note number 17. Right, then the next thing, the last part of our seminar this afternoon is just to consider some specific questions that were sent through via Danny. There were 3 questions that came through. One, looking at the mechanics of deferral of CGT when you are applying paragraphs 65 and 66, and linked to that is deferral of recoupments of wear and tear allowances. And I'll go through a little bit of an explanation of that in a moment. And then interest paid by an individual. Can a taxpayer claim interest on a loan agreement? Well, the answer to that really comes down, you're looking at, can the taxpayer claim a deduction for interest expenditure? And there, of course, you've got to look at the general deduction formula. So you would have to say, what was that loan agreement for? All right, did it fund, did the taxpayer use that to earn income? And so it's going to link to that. And also under the general deduction formula, is the taxpayer carrying on a trade? because the taxpayer can claim a deduction expenditure incurred in the course of carrying on a trade in the production of income. All right, so those are the key things. And that's, you really need to look at that to decide on whether you can get the deduction of interest paid on a loan agreement. And then employer-provided bursaries, and I'll come to that a bit later on. So let's look at these rollover provisions for capital gains tax. So as I say, there's 2 paragraphs in the 8th schedule, paragraph 65 and 66. I'm not talking here about corporate restructuring, which also has rollover provisions, but this is specifically where a person disposes of an asset, they have CGT, and the CGT is deferred. Paragraph 65 allows that deferral when you've got an asset disposed of by way of operation of law, theft, or destruction. It used to talk about involuntary disposals, but it might not only be an involuntary. It could be, for example, a disposal under the Land Act or something like that. So there's an operation of law causing you to make that disposal, but it's kind of like involuntary, or theft or destruction, also involuntary, right? Paragraph 66 enables a person to defer a capital gain when they dispose of an asset voluntarily, but they do that to reinvest in a replacement asset. Okay, so those are the 2 situations where you have these deferrals of capital gains. Now, of course, if you've had an asset and you've been claiming allowances on that asset, and now you dispose of that asset, whether you dispose voluntarily or involuntarily, you're getting proceeds. Chances are you're going to have a recoupment of your past allowances, which would normally be added into income in the year in which the disposal takes place. That section 84E, so 84A is the normal recoupment provision. 84E says that in these circumstances, when you've got the deferral of the capital gain under paragraph 65 and 66, then you also defer the recoupment, and you recognize the recoupment in line with when the capital gain gets recognized. So there are some requirements. So 65, which is your involuntary disposal, it's got to be, it doesn't apply to personal use assets. It must be disposed by under operation of law, theft, or destruction. So if a fire burns down your factory, it would come into this. Proceeds accrue by way of compensation, all right, like an insurance payout. And those proceeds must be equal to or exceed the base cost of the asset. So this deferral only applies to a capital gain, not to a capital loss. The full amount of proceeds must be expended in acquiring a replacement asset, and all the replacement assets must be from a South African source, contemplated in Section 9J or K. So that, again, we spoke about Section 9 earlier, and I said that that talks about what is from a South African source. So assets from a South African source is basically SA movable property or assets used in carrying on a permanent establishment in South Africa. All right, so that's that requirement. Then the contract for the replacement. So notice here, there must still be a replacement asset, even though it's an involuntary disposal. The contract for replacement must be entered into within 12 months, and all the replacement assets must be brought into use within 3 years. That 12 months and 3 years can be extended on application to SARS, but 12 months and 3 years is the default. And then the asset is not deemed to have been disposed of. So this only applies to actual disposal. So not like a deemed disposal like you have where a person ceases to be a resident, or if the person is deceased, they're deemed to have disposed of all of their assets. That doesn't come in here. It doesn't apply then. So it only applies where there's an actual disposal of an asset. So for example, of paragraph 65, your involuntary disposals, A Limited purchases a machine at a cost of 100,000. A few months later, the machine is destroyed by fire. So it's your involuntary disclosure. Remember, it spoke about theft, destruction, or disposal by operation of law. The company receives a compensation of 120,000 on the 29th of February 2020. It has a February financial year end, so it's still within the same financial year. They purchased a more advanced replacement machine. So they did replace, the machine was destroyed, but they did replace it. Okay, the more advanced machine costs more than the original machine. So you would first of all look at the disposal of the original machine. Cost 100,000, there would have been allowances claimed on that machine. So whatever the tax value was, you're now receiving compensation of 120,000. You'd have recoupments between the tax value and 100,000, and you've got a capital gain of 20,000. Okay. Now the issue is that if paragraph 65 applies, then we don't recognize that 20,000 Rand capital gain. In fact, we don't recognize the recoupments either in the 2020 year of assessment. That is deferred, and it's recognized in the next few years. So the capital gain is spread over the future years in proportion to the capital allowances on the replacement asset. So if this is an asset that qualifies for a Section 12C allowance, 40% in year one and then 20. So then you would say, right, in year one, we're going to get an allowance of 40%. So that capital gain that was deferred of 20,000 in year one, so the next year, when this machine is brought into use, the new machine, the replacement machine, you would then include 40% of the capital gain and then 20 in the next 3 years. Similarly, with the recoupment, it'll be the same treatment. Okay, so there you see it coming through here. On the new machine, you're getting a 40, 20 on the 150,000, and the capital gain of 20,000 that arose at the end of February 2020. But because paragraph 65 applies, you don't bring it into account then. You roll it over and bring it into account in proportion to these tax allowances. And with a recoupment, it would be the same treatment. Okay, so that's paragraph 65, involuntary disposals. Paragraph 66 talks about voluntary disposals, but where there has been a replacement asset. It is just a little bit more specific in terms of the types of assets that qualify. So again, it doesn't apply to personal use assets, and it talks about a voluntary disposal, but it only applies to assets that have qualified for these allowances. Of course, most times we see the 11E and the 12C, but notice that it doesn't apply to the Section 13 building allowances. Okay, so it's really only your movable assets that come through here. Again, the proceeds must equal or exceed the base cost. At least the full amount of proceeds must be used to buy replacement assets. All these other requirements are the same. Okay, so the only difference is that it's a voluntary disposal and it only applies to certain types of assets or movable assets that have qualified for these allowances. So let's look at this example that I got from Hooft, because there wasn't one in the SARS guide. So we've got B with the December year end. It bought a new machine that cost 100,000, and in March 21, it sold the machine and it replaced it. So it's a voluntary disposal, but it's got a replacement with a new machine. And at least the full amount of the proceeds on disposal of the old machine are used to buy the new machine. So at least the full amount must be expended. Okay, so here we've spent much more, so we're well within that requirement. So what happens here? So we've got the old machine, machine one, and there we bought it. We've claimed the 12C allowance for 2 years, 2020 and 21. Of course, we use this machine for part of the 21 years, so we get the allowance for that year. So the tax value of machine one on the date of disposal was 40,000 Rand. We then sell that asset. We get proceeds of 120,000. The recoupment only up to the original cost. Just a point here, when you work out the capital gain and we say proceeds is 120,000 minus any amount already included in income, which is the recoupment of 60,000. Okay, so that doesn't get included in proceeds. So, all right, so but in terms of working out the recoupments, you can only recoup what you've already deducted. So that's a 60,000 comes through as a recoupment over here. All right, so we've got a capital gain, we can see, of 20,000, but we've got a recoupment also of 60,000. And the taxpayer elects, so here you would actually elect paragraph 66, all right, like with 65 as well. Again, 65 is also something that the taxpayer elects in their tax return. So here you elect that we're not going to be taxed on the capital gain in the first year. We're going to defer that, and we'd include it in proportion to the allowances that are granted on the replacement machine. So here's the replacement machine, cost 200,000. In the first year, which is 2021, all right, in the year in which the other machine was disposed of, we get a 40% allowance on the new machine. Okay, and then we would have to also add to income part of the recoupment. So I said we had a recoupment of 60,000 on the old machine. We now bring in 40% in year one. So we bring in 24,000 in that particular year. In the following years, the machine 2 would get the 12C allowances of 20, which is 40,000 per year. And your remaining recoupments, we had 60,000 times 40% in year 1, 24,000. In the next 3 years, we'd take 60,000 times 20%, be 12,000 per year. So 12,000 over 3 years is 36,000 plus the 24,000 we recognize here. So we are bringing the 60,000 recoupment into account, but spread out over the ensuing 4 years. Okay, in proportion to the allowances that are granted on the new asset. Okay, so that's how that applies. Right, so that's the deferral. I hope that has answered your question. And then the interest on the loan, as I explained earlier, you need to look at the general deduction formula, the purpose of the loan. Also, the issue around the general deduction formula requiring that the person is carrying on a trade. If a person borrows money and pays interest and then uses that borrowed money to invest and earn interest, if the person's not a money lender, that in itself is not carrying on a trade. But then Practice Note 31, which is still valid, does provide that although you're not carrying on a trade, SARS will allow the deduction of interest in that case, but only up to the amount of the interest actually earned. So you can't create a loss situation there. If you were carrying on a trade, potentially you could get a loss situation, but of course you do have the limitations coming through Section 20, the assessed losses, and also Section 20A. But Section 20A only applies to individuals who have been taxed at the maximum marginal rate. If you have interest that is actually incurred in acquiring shares, for an individual, you wouldn't get a deduction for that because shares produce dividends which are exempt. So it's basically Section 23F. You can't deduct expenditure incurred in producing exempt income. But if you had incurred that expenditure in buying listed shares, then you can add 1/3 of the interest to the base cost in terms of paragraph 20 of the 8th schedule. Okay, right. And then the last question related to employer-provided bursaries. And I guess this links to the amendment that came into effect through the latest set of amendments that were promulgated in January 2021. Now, to start off, if you have an employee who derives any kind of benefit from the employer, that would indicate that there would be a taxable benefit, all right? So without this exemption, if the employer paid for something for the employee, or indeed paid the children's school fees or paid for the employee to go and study, that would be a benefit that the amount paid by the employer would be taxable, would come into gross income. This exemption provides a specific exemption that says that although you've now got this amount that's come into gross income, the amount is exempt if it is a bona fide scholarship or bursary that is granted to enable or assist any person to study at a recognized educational or research institution. All right, so the exemption starts off by saying this is what is exempt, but then it's got two provisos. The one talks about that the exemption does not apply if the scholarship or bursary is granted to an employee unless the employee has undertaken to repay if they fail to complete their studies. The second proviso deals with bursaries provided to relatives of an employee, all right? And that's the one that's received all the attention recently, because that second proviso says that even if it is a bona fide scholarship or bursary granted to a relative of an employee, the exemption will not apply unless the employee is earning not more than 600,000 a year, and then you would have limitations on how much exemption applies. So there's the first proviso dealing with bursaries and scholarships going to employees directly, and there's no change as far as that legislation is concerned. The second proviso says the exemption won't apply if the bursary is going to a relative, if the employee earns more than 600,000. So the exemption only applies in this case where the bursary goes to a relative of an employee, only applies if the employee is earning not more than 600,000 a year. And then if the employee does qualify for this exemption, the amount of the exemption is capped, right? So we talk about bursaries and scholarships to relatives of the employee. So for example, if the company pays the children's school fees, if the children are still at school, then your exemption is capped at 20,000 Rand per relative. The 30,000 applies if the relative is a person with a disability, then you get a higher exemption. If the person is studying beyond school level, beyond grade 12, all the way up to PhD, that's NQF level 10, then the cap on the exemption is 60,000, or if the person is a person with a disability, 90,000. Okay, so far, this is what we have seen in previous years, that you've got the exemption, but the exemption does not apply if there's a bursary to a relative unless these thresholds are met. What's come through as a result of the exemption, of the amendment to this, effective from the 1st of March, is the addition of subparagraph 3 to this proviso, which says, remember, this is saying the bursary exemption shall not apply if any remuneration to which the employee was entitled or might in the future have become entitled was in any manner whatsoever reduced or forfeited as a result of the grant of a scholarship or bursary. Okay, so the thing is that what it's saying to us is that if there's any element of a salary sacrifice, then that exemption is not going to apply. But it's talking about an exemption for a scholarship or bursary granted to a relative of an employee. If it's a scholarship or bursary going to an employee directly for the benefit of the employee, then it's the first proviso that applies. The exemption won't apply unless the employee agrees to reimburse the employer if they fail to complete their studies for reasons other than death, ill health, or injury. So that's scholarships or bursaries going to employees. When you've got scholarships or bursaries going to relatives of employees, then we are into proviso 2. And here it says that if there's any element of a salary sacrifice, then the exemption will not apply. If there's no element of a salary sacrifice, then the exemption will only apply if the employee is earning not more than 600,000 per year, and then the amount of the exemption is capped, as I've indicated over there. All right, so what this means is basically shutting down a lot of the exemptions that would have been there previously, because we didn't previously have this restriction around salary sacrifices. In fact, we did have this restriction prior to 2006, way back in the 1990s when this exemption was first introduced. It did have the same condition around salary sacrifices. But then this restriction around salary sacrifices was removed in 2006 because it was felt to be overly onerous and it detracted from the real benefits that were intended to flow from this exemption. And in fact, then the use of this exemption grew and grew over the ensuing years, and particularly around the fees must fall crisis in sort of 2014, 2015, we saw the amount of the exemption was hiked, the amount of the remuneration limit was raised, and there's a lot of focus placed on this exemption. So a lot of employers then rose to the challenge and did provide schemes, and not necessarily, I'm not saying that in a bad way, but they did provide systems and schemes where employees could validly enter into a salary sacrifice. So, for example, if the cost to company package was 500,000 a year, they could, before the remuneration accrued to them, forfeit the right to receive, say, 50,000, and that 50,000 could be used to pay school fees, and then they'd only be taxed on the remaining 450,000. However, that is clearly a salary sacrifice, and so it comes into what is impermitted here. And so if you do enter into that kind of salary sacrifice, and notice it says not just what the employee was entitled to, also any amount that the employee might in the future have become entitled. So this is very broad-based in terms of considering salary sacrifice schemes. And so if there's any element of a salary sacrifice that is underpinning this bursary scheme for relatives of employees, then the employee will not get the exemption. All right, so that's the story as far as bursary exemptions are concerned. So I hope I have answered your question adequately there. Okay, so I think that does bring me to the end of what I had planned to talk about. So I'll just give you a couple of minutes if you do have anything that you want to ask about. Here we go. So Ian, in my experience, many parents have one or more adult children still resident at home. It seems to me that precautions need to be taken. Cash contributions by the children towards their accommodation could carry tax risk. Yeah, I mean, this is an issue, Ian. So this absolutely, your observation, I concur with that 100%. And of course, if a person is renting out property, it's not a question of who you rent to that determines whether that amount is taxable or not. If you're receiving income from rental, then it comes into your gross income. The question is, of course, the deductions that you can claim against that. Now, the issue is, of course, if you are renting and your children are paying you rental, maybe you're running at a loss. And the question is then whether you can claim that loss, because it's in that circumstance that Section 20A might well come into play to ring fence that assessed loss. And indeed, it might also be a case of SARS arguing whether you're actually carrying on a trade, but trade does include the rental of property. So I would suggest that you are carrying on a trade, but then the question is whether you could actually claim any losses that you incur. When does the new UIF threshold come into effect? Renee, this is $1 million question. So this has been such a confusing situation because initially this was all announced in the budget speech and the draft notice was released for public comment that as of the last time I looked at the SARS website, which was yesterday, there was no further confirmation as to when it's coming into effect. So at this stage, the answer is, I don't know. We'll have to keep an eye on the SARS website and see if they do give us some announcement sometime soon. Okay, all right. Are there any other questions? No, I don't see anything. Okay, Stan, over to you.
Okay, thanks, Prof. Jackie. As usual, fascinating stuff. Just to everybody you'll be returning a couple of times still in the year, and notices will be going out timeously. There are 2 forthcoming presentations, one in June and one in July. The one is Edwin Selbst in June and in Munir Hussain in July. We'll be sending out the notice soon. Your certificates are ready to go out. We're just checking the arithmetic, and we'll be sending them out the next day or two. And so to everybody, thanks for your attendance. Thanks for supporting us, and stay COVID-free, stay safe, and good night to everybody.
Jackie, before you go, I think there's one question someone in the chat wants to ask.
Okay.
So I'm going to just allow them to talk. They're on their phone, so they're not going to be able to type it out. So I'm going to allow them to talk.
Oh, sure.
If they want to ask.
Okay, I will listen carefully. Yes.
Brian, if you want to ask a question, it's open up to you now.
Oh, thank you very much. My question concerns a practical issue with SARS e-filing and a verification and an audit of medical expense deductions. There was a review. We sent in all the vouchers for the medical expenses claimed, and then SARS said there was more information required. There was no letter to that effect, but when I phoned the call center, they said there's a new requirement that I could find on the web. I couldn't find it. And this is that if you claim under code 4020, medical expenses submitted to the medical aid, and you claim on 4034, medical expenses that weren't submitted, you would have got to submit 2 schedules and cross-reference the 2. Now, I then said, how much time have we got for this? Because normally it would be 21 days and then another 21 days. And they said, you've only got 10 days. Now the client is trying to get the information from the medical aid, but due to COVID and the lockdown, it's quite difficult. The client is in their 80s, has 2 eye operations. We will try and oblige, but I wonder if other members of the Zoom meeting or you have any advice or comments to make on this.
Yeah, thanks for that. I think, as you say, are there any other people who have dealt with this particular situation who might want to share their experiences? Unfortunately, if SARS has asked for the information, of course, then they're not going to back down. You're going to need to provide it. I think the key thing is that you could perhaps request an extension from them. Anybody else want to share anything relating to medical expenses and submitting additional information? In the meantime, I'm going to address Gideon's question. If an employee receives a bursary which is exempt, is the expense deductible by the employer? Yeah, I guess, you see, with the draft bill that came out last year, they initially were going to say that if you lose the exemption for the employee, then the employer loses the deduction. But fortunately, that proposal did not see the light of day. It was dropped during the consultation process. So technically, yes, the employer could still get the deduction, even if the amount is not exempt in the hands of the employee. And if it is exempt in the hands of the employee, potentially the employer could still get the deduction, because the issue is that the employer has incurred expenditure. And as long as it meets the requirements of the general deduction formula, then it would qualify for deduction. And the issue here is about keeping a happy and contented workforce, and it's part of your costs of employment. So all things being equal, it should be allowed as a deduction. Okay, anything else? Otherwise,
there's one more in the question answer section.
I see it, yeah. Okay, Inter vivos trust, property was purchased and financed by the trust. The trustees exercise their discretion and invest the property in a capital beneficiary. So yeah, if the trustees vest the asset in the beneficiary, that's when paragraph 81 applies, okay? And that does say that the resulting capital gain is not taxed in the hands of the trust, it's taxed in the hands of the beneficiary. So yes, it would be taxed in the hands of the beneficiary under paragraph 80, subparagraph 1.
I'll just make a comment about the discovery medical, or not discovery, but the medical claims over and above what the medical aid will pay. So the advice that was given to me is that you must always put your claims in, regardless of whether you still in whatever process, because they will print out that and give it to SARS as the claims in excess. So that's probably the simplest way. But I've also heard that you could sign an affidavit, make an affidavit to the effect of the amounts that you had, and sometimes they'll accept that.
Yeah, that's a good suggestion. You know, if things are becoming a bit time consuming, then that is certainly a good suggestion, Stan. Thanks for that. Yeah. Okay, I see there's another question. Okay, just to say thanks. Thank you very much. Yeah, it's been great to have you all here. And I hope that, that has been helpful for you and that it's been a useful bit of time spent. Yeah. So thanks very much, everyone. I'll say goodbye then.
Afternoon well spent.
Thank you again, Jackie. It was very
thanks, Danny.
Informative.
Lovely. Thank you. Thanks, everyone. Bye-bye.
Cheers, everyone.